I'm visible,
Okay.
right?
Yes, ma'am, you are visible.
Okay.
Should we start?
Yes, I think we should start.
A very good afternoon to all. I, Anindya Prasad Konar, take this opportunity to welcome you all on behalf of Center for Legal Studies, Geetharathan International Business School on this Personality Development Workshop. Geetharathan International Business School was established in the year 2004. GIBS is affiliated to Guru Gobind Singh Independent University, Delhi, and it approved by Bar Council of India for its law programs and All India Council for Technical Education for its other technical courses. GIBS has been graded as A by National Assessment and Accreditation Council in the second cycle. GIBS has been rated at A+ by State Fee Regulatory Committee, a fee committee of Government of NCT and Delhi, and GGSIP University. GIBS has been rated highest grading A by Joint Inspection Team of Government of NCT of Delhi and GGSIP University. GIBS has been rated A by Audit Cell of GGSIP University for past 8 years. GIBS has also been rated as number 2 Pan-India by Times B School Survey consecutively for the year 2018 and 2019. GIBS is currently offering following programs like BBA LLB, BA LLB, MBA, MBA International Business, and BBA. The topic for today's workshop is Non-Disclosure Agreement, Protection of Intellectual Property. And for today's program, we are honored to have with us as resource person, Dr. Sunanda Bharti. Ma'am, we welcome you on behalf of Geetharathan International Business School, Center for Legal Studies, to our program. Let me introduce our honorable speaker. Dr. Sunanda Bharti ma'am is currently serving as Associate Professor at Faculty of Law, University of Delhi. She is also a certified professional mediator. She has been alumnus of esteemed institutions like SRCC Delhi, Faculty of Law, Delhi University. She has been teaching at Faculty of Law for more than 15 years. She has published several research articles in various national and international journals. She is also a regular contributor to articles in several newspapers and blogs like Times of India, The Hindu, etc. She has presented more than 10 research papers in national and international conferences, and she has also participated in various national and international faculty development programs. Some of her research and teaching interest includes intellectual property law, alternate dispute resolution, jurisprudence, law on negotiable instruments, and taxation law. Ma'am, on behalf of Center for Legal Studies, will welcome you to our program. Now, I would request our honorable speaker to take the program forward.
Thank you so much for the very nice introduction. Um, I'm really pleased to be here today to have this opportunity of interacting with students of Geetharathan Institute. And yes, as you all know, the topic is there before you. The topic is non-disclosure agreements and IPR. So I'll try and do as much justice to the topic as possible, though my slides they do not contain any written content as such. But then, if you follow the what I'm speaking very closely and are able to interpret the iconography on the slides, you will be able to know, you'll be able to understand what thought is being projected and what the idea basically is that I'm trying to convey. Okay, so with that, I think we should begin. And let's come to the first slide. What is NDA? Now, what is NDA? Next slide, please. Yes. So what is NDA? NDA is non-disclosure agreement, of course, but what exactly it is, what under what law would it fit, and all that that needs to be understood properly. You see, for companies and organizations, basically businesses, all sorts of businesses, not only big time companies, but even say, for instance, startups and small and medium enterprises. For all sorts of businesses, all kinds of assets, they need to be protected. So assets need to be protected, and same is true for intellectual property as well. So the businesses, they are required to protect their intellectual property just like any other tangible asset. And so when we say IP is also an asset, what is different about intellectual property? See, the basic difference about intellectual property is that intellectual property, primarily speaking and basically speaking, is all about money. It is nothing but sheer economics that comes into play when we talk of intellectual property, barring a few exceptions, of course, wherein say for instance, some portion of copyright law, I would say that okay, I have created a certain work not to earn money. My idea was not to monetize it in the first place, but just to give a vent to my creativity or to get that intellectual stimulus. That's the only reason why I created it. So barring those exceptions, intellectual property is all about money. So the need to protect the same from being leaked out or unauthorizedly exploited by someone, it becomes very critical. Okay, and that is where intellectual property can be sort of in a way differentiated from other assets. And see, when I say critical, what I basically mean is that the risk with IP is higher, the stakes involved are high, and hence the companies and the businesses as such, as I said, it could be a startup or a small and medium enterprise or a big multinational or a domestic company, whatever the nature of or the expanse of the business, there is a paramount need to minimize that risk surrounding their intellectual property, and it is this need that gives rise to non-disclosure agreements. Okay, as you can see on the slide, there is risk associated with IP, and that can be linked to why NDAs are necessary. Okay, next slide, please. So the next slide properly deals with why NDA. So the need for non-disclosure agreement. What is the need for non-disclosure agreement? This is the detail of it. And so once we have understood that there is a lot of risk associated with intellectual property, and this risk particularly involves leakage of information, the businesses, what they do is they enter into an agreement with whomsoever they are dealing with, right? So all and sundry, basically, or broadly speaking. So it could be employees, it could be professionals to whom work has been outsourced. It could be lawyers who have been roped in for defending the IP claims of that business. It could be potential licensees. It could be potential prospective buyers, potential investors, anybody to everybody, basically. And why? So how is this done? There is the process is pretty much the same as might be involved in any other small time contract. How it is done? It is done basically by signing an agreement with all these various parties, various entities, and it is an agreement signed for or that aims at the protection of confidential information related to the concerned intellectual property, that is the intellectual property in question, and is often sometimes known as the confidentiality agreement. In fact, it might not be out of place for me to mention the two very famous examples, just to just to highlight how relevant NDAs can be for those who are dealing particularly with the trade secret branch of intellectual property. I mean, businesses like Coca-Cola and KFC, that is Kentucky Fried Chicken, they have managed to keep their trade secrets a secret, so to say, for more than 100 years or so now. And how do they do it? How have they done it? Now, of course, apart from the 110 measures and mechanisms and ways and means that they might have employed to do it, one commonly used tool is the non-disclosure agreement, or the NDA, right? And you see, the very nature of the non-disclosure agreement is such that it allows the concerned company, the business, to share the information in regard to its intellectual property with a certain someone without unduly compromising the confidentiality of that IP. Say, for instance, you see, recently I had the good fortune and an opportunity to interact with a person, a high-ranking official, who is basically employed with the oil and gas sector. And I thought that, okay, let me just try and find out how NDAs work in that sector, um, in a big and a very well-established oil and gas company. So I'm taking that bits and pieces of that conversation, and I have tried to sort of develop an example out of it. So, for instance, if an oil and gas company that deals broadly with designing and constructing refineries, okay, it shares information regarding the layout designs of their refineries. Now, the layout design, when we talk of layout design of their refineries, which it might be a copyrightable subject matter, or say, for instance, it shares information regarding new patentable processes, that enables them to, say, remove sulfur from crude oil, which might also, in addition to being a patentable process, that might also be a trade secret. And so they share such information with a certain client or with a certain entity, and they do that without signing a non-disclosure agreement. Then it is likely, and it is very likely in the business world, that this client with whom they have out of trust, or out of whatever be the reason, they have shared this information. This client may use it without unauthorizedly use it, that is, or sell it, that is pass on the information to a competitor for better financial gains. So, as I said, IP is all about money. So, more the money one gets to derive out of selling a certain information, the better. So he could use it, he could sell it unauthorizedly if no non-disclosure agreement is signed. And hence, in such situations, the non-disclosure agreement comes in handy and makes business sense. Right? So this is one broad reason which spells out the need for having a non-disclosure agreement. Now, with that, I think I should mention a bit about, because this is law we are talking about. So, legally speaking, what is an NDA? NDA is a legal contract between the parties, basically, that ensures that the disclosure of confidential information is limited for a specific purpose and for a specific period of time. Usually, for a specific period of time. Usually, a certain duration is mentioned, and of course, the parties also have to agree not to disclose. Parties, that is particularly the recipient, has to agree not to disclose the information shared with any other third party. So, as I said, the non-signing of an NDA can lead to innumerable and immeasurable hassles for the parties involved. So the need, so the slide was on need for an NDA. So I would emphasize that insofar as need is concerned, see, the need for an NDA is critical, and the need is obvious when it comes to protecting intellectual property. So next slide, please. Okay, so effect of NDA. Effect of NDA, you can see two icons, and I will try to broadly first icon. These icons were supposed to come one after the other in the slideshow, but for some reason they are coming in one go. But doesn't matter. Let me just um, try and make the most of whatever is happening right now with the slide presentation. So the effect of NDA is something that in a way, and I think I can safely say that this is one aspect uh, that is hardly given the due recognition and weight that it deserves. But I feel that it is immensely important to highlight uh, the effect in the passion in which I want to. I have just I would share it with you in a while. So the signing up of an NDA creates, apart from, yes, binding the parties to not disclose the information. Why? Because the stakes involved are high. Why? Because they are likely to face a legal a lawsuit if they breach that NDA. Of course, that is also one of the compelling reasons why NDAs are complied with, and that is one of the effect of an NDA. That okay, you out of fear you sort of develop a certain compliance, but the signing of the NDA creates more trust between the parties signing it. And since one of my other subjects that I teach is alternative dispute resolution, I thought it would. I considered it to be my bounden duty to highlight this fact that if there is a well drafted NDA in place, right? The reason for a certain conflict might not arise in the first place. So uh, a good NDA ensures that despite heavy negotiations, agreements, or disagreements for that matter between the parties, the owner of the information and the recipient concerned, the information needs to be protected at all times. It creates that mental attitude, and it creates that mental makeup, right? So it enhances trust between the parties. That is one of the very you can say important effects of an NDA, and it acts as a deterrent, of course, and it creates a culture of compliance. Culture of compliance is that yes, there is a certain protocol that needs to be adhered to, and let me not breach that protocol. That sort of an attitude it develops. So, and again, if I may share here that again, I was speaking to one industry person uh, who basically is the owner of a certain startup, right? And to develop that culture of compliance, what that person has done is to be very strict. He has devised a very strict non-disclosure agreement. So I think I should highlight that some types of non-disclosure agreements are so strict that they may not give the permission to a certain person to even sub-disclose the information to other employees within the same organization. See, sub-disclose is when you are not allowed to disclose even to a co-worker. So if a certain person is working on, say, on a project dealing with technology X, right, in, say, Apple computers, her NDA would not permit her to disclose anything about that project to a co-worker working on another project dealing with technology Y within the same company, that is Apple. Okay, so most of the good, as I said, I emphasize, most of the good established technology-driven businesses that take their IP seriously have no option but to take these NDAs very seriously, to not only protect their IP but also to develop a culture of compliance. Okay, so next slide, please. So the next thing is, when we talk so much about the fact that one of the effects of the NDA is that it builds trust amongst the parties. It tends to develop a culture of compliance and so on and so forth. The immediate next question that one should ask oneself, or at any cost it should come to one's mind, is for how long should this compliance last, right? And to be very frank here, it depends actually. So there is no standard answer to this question. So the answer that I can perhaps I would like to give. Let me put it this way: the answer that I would like to give is it depends. It depends on what? It depends on a number of things, multitude of factors that need to be considered. So it depends, say, for instance, on the nature of the intellectual property that is sought to be protected through that NDA. As already pointed out, if it is a trade secret that we are dealing with, sorry, if it is a trade secret that we are dealing with, the non-disclosure agreement might just bind the parties not to disclose the information for an infinite period of time. That's possible, right? So every non-disclosure agreement is as unique as the parties want it to be. It is as unique as the information that needs to be kept confidential, and so on. And of course, it depends on it also depends on what the party's intention is, right? What the parties have end up mutually agreeing to. And usually, again, very broadly speaking, the terms ranging from 1 to 10 years are considered to be standard, meaning thereby that okay, this information would be kept confidential by the recipient for a maximum period of 10 years. And again, for trade secrets and for different intellectual properties, where the concerned parties are very particular about the duration, they can tweak it. So the duration of confidentiality may last indefinitely for trade secrets, and they may introduce expressions such as long as possible, or as is necessary for other forms of intellectual property. Okay, so the for how long should the compliance last is the answer is it depends. Usually it is 1 to 10 years that they are taken to be the standard. So next slide, please. Right. Okay. So where are NDAs used? Since we are I've already briefly stated that an NDA is a very useful agreement, not only for multinational companies that might be having IP assets worth crores, but also for startups and small and medium enterprises. And if I may add here, particularly during COVID, during the times that we are living in, unfortunately, a number of startups have begun to mushroom around creating COVID-19 compatible assets or products. Say, for instance, We have sanitizing machines, different types of sanitizing machines. This whole big business of non-touch technology, it has come up like a big thing in the market. So we have non-touch elevators, we have non-touch faucets, that is taps. We have AI integrated bots, that is robots, that are basically cooking your food in restaurants and so on, or at least not so much in India right now. But then, yes, work is on this technology. All this is at a very nascent stage, at a very, uh, you can say, um, beginning beginner stage. But all is important. It is important to protect all that, right? Despite it being at the nascent stage. So this is because, in my opinion, again, it is basically at this stage of inception and growth that that there can be many instances where uh, the involvement of an outsider can pose a potential risk of exposure. That is exposure of information to the outside world without you knowing it, or without your consent or authorization. So in today's cutthroat competitive world, the absence of a non-disclosure agreement can really upset your business plans big time, and lead to jeopardizing the confidentiality of the information in the first place. Okay, yeah, completely. So, uh, where are NDAs used? NDAs are used by big corporations, by small scale enterprises nowadays, basically, right? By all sorts of big and small businesses. Now, since we are on this slide, um, uh, which talks of where NDAs can be used, let me. I covered two icons. I think so. This icon, if you can see the cursor, I'm not sure if you can see the cursor. This talks of this is symbolic of startups. This talks of SMEs, of course, and then there are two other icons that I haven't dealt with. And allow me to briefly explain why the other two icons are there on the slide, because so let me give you a sort of brief overview of where they have been used successfully, the NDAs. Of course, patents and business methods and processes have been protected since ages through NDAs. So that's nothing new. Not, so no new development. They are still being protected through NDAs, and very carefully drafted NDAs for that matter. It is, in my opinion, the or in my assessment rather, it is the media and entertainment industry space uh, that I feel that India would establish themselves firmly in India in the coming years. Okay. Uh, Sorry, am I audible? Am I audible?
Yes, ma'am, you are audible.
Right. Okay. So as I was saying, I was trying to explain the fourth icon that is, sorry, the third icon that is there on the slide. As I was saying, it is the media and the entertainment industry that is likely to use NDAs in a big fashion in the coming years, because see, in these industries, a lot of vital information is shared with outsiders. Um, and let me just, though didn't, I don't have a ready example, but um, in the random example that comes to my head right now is, let's take the example of a script or a screenplay. Now, it is a copyrightable subject matter if it is sufficiently original, of course, right? And a scriptwriter uh, or a screenplay writer, as the media industry works globally, not only in India, has to share his script with so so many producers and production houses before it gets accepted and is taken as a film. That is, if at all it is taken as a film. And so the scriptwriter in this case um, would benefit definitely from the NDA, because the NDA would ensure that no one is using his script without his permission. Okay, so one big change that I in my assessment is right on the anvil, insofar as NDAs is concerned, is uh, NDA and IP is concerned, is that it is likely to be exploited big time by the media and entertainment industry. And the last icon, coming to the last icon, it denotes, it is symbolic of the fashion design industry. And when we talk of the fashion design industry, not so much in India as abroad, it this industry is also likely to derive a lot of benefit from NDAs, to ensure that designs that are not meant to be shown in the public before the exhibition of fashion shows, they remain so. They remain they remain a secret. They remain confidential. So, as I said, not so much in the Indian fashion industry scene, because here, say, the the designers who would be using, who are using, I know for sure, India successfully, is are the big time fashion designers. So the likes of Rohit Bals and Ritu Kumars and who's that, Manish Malhotra and Sabyasachi, right? So these are big fashion houses that right now are dealing with, are exploiting NDAs to their benefit and protecting, in order to protect their intellectual property, right? So, but in the coming years, this usage is likely to expand and is likely to boom, right? To take an example, that to take an easily relatable example, because most of you are students who either might be doing internships, or I believe are likely to enroll in one internship or the other in the coming future. Yes or no? Is my assessment correct? Yes. Are the students, the members of the audience?
Ma'am, the students not able to respond. They can respond in the chat box. So at the
Okay,
end, they might put their question. They are putting their questions.
right.
But for this, only limited person can respond over
Okay.
voice.
So let me just presume that they are familiar with internships and they are likely because for a law student, internships are inevitable and an intrinsic part of the curriculum these days. So uh, what I was trying to get to is to give a closely relative, an easily relatable example. So, many good law firms these days, uh, in many good law firms, where the employer is interested in keeping the information private and confidential, uh, even interns may be asked to sign an NDA. Right? So, this is all about, as the slide says, where NDAs can be used, or where NDAs are likely to be used in future, and where NDAs are already being exploited in the current scenario. Next slide, please. Right. Okay. So three icons and quite self-explanatory. First is what happens on breach of on when a non-disclosure agreement is breached. What happens? So the first icon, this one, denotes breach of a contract. Right. So the any recently drafted NDA, and this again, it's a blanket statement, but I think I can safely give it out this way, that any recently drafted NDA would mention and highlight the penalties for not complying with its requirements. Okay, what would happen if you do not comply with the requirements of the terms of the non-disclosure agreement? And broadly speaking, again, if confidentiality is breached by the defendant, that is the recipient of the information, at any stage during the term of the agreement, or as per the terms and conditions of the agreement, then the plaintiff, that is the owner of the information, can either take penal action against the offender, or can proceed as was agreed upon in one of the terms or one of the clauses of the contract. So the penalties may involve compensation, yes. So the second icon on the slide denotes money compensation, or it might involve an injunction. Injunction is to restrain the other party from doing whatever it is doing, right? So the penalty may involve a compensation or an injunction. So say basically the owner saying, okay, stop doing whatever you are doing, and through a court case of court, through the court of law, or through a cease and desist order if it works. Now, but here, if I may add, because from whatever limited literature, limited case law that I've had the occasion to go through, and whatever, but I've had a number of interactions with people from the industry, right? That is law firms and those who are into all different types of businesses wherein they want to protect their intellectual property. So thankfully, I'm in close touch with such industry people, and from whatever I've gathered, I think I should emphasize that yes, penalties involve compensation and injunction, and or both, um, uh, for in order to vindicate the rights of the owner and to move against the recipient of information. But a party is entitled, usually is entitled to relief by the court only when it has made an effort to protect the confidential information through a non-disclosure agreement uh, or something similar. Okay, so the point being that the courts are usually not amused if the plaintiff, that is the owner of information, himself has not taken any measure to protect his intellectual property through NDAs, or has been evidently lax about the same, right? So what happens in breach of NDA is this. Uh, I think that's pretty much what I wanted to discuss. But let me uh, share a tangential point, which might not be there on the slide as such, but then I think it is relevant, and because many a times this question crops up in one's head as to when should one enter into an NDA, particularly when the information that is sought to be protected is an IP information. Now, the answer to that question again cannot be a straitjacket standard type of answer, but there do exist various circumstances which may leave the owner of a certain information, certain sensitive information, to 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 decide to take that decision that okay, now is the time to enter into an NDA. So there do exist various circumstances which might denote the so to say perfect timing for entering into an NDA. Say for instance, when an invention, if the IP concerned is in relation to an invention or a business idea, So when that invention or business idea is shared with potential investors or distributors or partners, that would be the right time to enter into an NDA with all these parties. Okay, or when a certain technology or a new product is being so to say showcased to a prospective licensee, that might be the right time to to enter into an NDA with this prospective licensee, or when some kind of professional services are being availed of from from domain experts or in labor law, the term that is used is independent contractors under a contract for service. That might be the right time to enter into an NDA. So when should one enter into an NDA is case sensitive. It is dependent on a number of things, but mostly the circumstances. If you are vigilant and you are active and you are aware of what uh, you want to do, how you want to lead your business and the legalities around the business. If you're aware of that, then the circumstances usually give you the lead as to when the right time is. Okay, so next slide, please. I think next slide, please. Yes, important clauses of NDA. This has 5 icons, and which itself should lead you to conclude that mm, though I'm not a practice person, I'm not into the practice of intellectual property. I teach intellectual property, but then, as I said, I do have have had a number of interactions, and I keep that interaction, very organic, um, most of the times, so that with the industry people, so that uh, collaborations and information sharing and exchange of notes can keep happening. And though I haven't drafted a non-disclosure agreement for the obvious reason that I'm not into practice, but then I do have come across and read through a number of non-disclosure agreements, so to say. And broadly speaking, again, this is my assessment of what could be considered or what should be considered as an intent in an NDA. The first icon is showing a file, and this and with a lock, and so the first point is uh, the one of the clause should definitely deal with, in as elaborate and succinct fashion at the same time as possible, the nature of the confidential information that is sought to be shared and the restrictions within which that information can be shared. Right. So the owner of the information must agree. One of the clauses must say that the owner agrees to disclose the information to the recipient uh, to facilitate future business dealings between the parties. And likewise, the recipient must agree to receive this information, and of course, not only agree to receive the information, also undertake not to copy, disclose, use, sell, or offer to sell any or all of the concerned information. Um, Basically, the idea is that the recipient of information basically has to agree not only to keep the concerned information confidential, but also to take all necessary and reasonable steps to prevent unauthorized disclosure or use of that information. Right. So that takes care of the first icon, that is what confidential information that the owner is trying to share with the other party, the recipient, needs to be spelled out and needs to be punched out as unambiguously and clearly as possible. Uh, which brings us to the second icon. The second icon on the right, the second icon should be the middle icon, which shows a bullseye sort of an icon. Because another aspect, when we say that the NDA has to be clear and unambiguous, one aspect of that clarity uh, is also to emphasize and to spell out in as many words in one of the terms of the agreement that this is a non-disclosure agreement and it is not an offer for sale or license out. I'm not offering to sell or license out this intellectual property to you. So so basically the idea is to is that this clarity bit emphasizes the fact that the NDA has to hit the bullseye and not beat about the bush insofar as the terminology used is concerned. Okay, so the third icon, as I see, is the the domain icon that is there on the right, which shows three pins on a certain area. Now, what does it denote? It denotes the domain within which the domain of the NDA basically. So the idea is that the owner of the information might share the concerned information either out of compulsion or out of volition, uh, uh, procedural compulsion that is, with A, B, C, D different parties. So, say in the form of patent application, when he fills a patent application, he might have to reveal a lot of things, or in the form of copyright applications, or any disclosure for that matter by the owner to any other person. So he might disclose to a number of people, but the fact that he has disclosed to A, B, C, D persons does not mean that this agreement, which he has entered into with this person X, changes, or the fact that he has shared the information with so many other parties does not have any bearing on this particular agreement. So the idea is to emphasize that this agreement shall remain in force in spite of disclosure of information by the owner in the form of patent applications, copyright applications, etc., to all the other authorities. Okay, so the NDA must clearly specify uh, the the obligation of the recipient as clearly as possible. Then we have there is this lock icon. Lock icon is symbolic of the consequences of breach, because as you can see, the lock there is a break. It is symbolizing as if the lock has been broken. So it is denoting consequences of breach. That means the any again recently drafted NDA has to specify the consequences of breach. Otherwise, what's the point in drafting in basically entering into a non-disclosure agreement? So the recipient has to agree. Recipient of the information basically has to agree that in case there is a breach on his part, that is, in case he breaches any of the promises contained in the agreement, the owner would be entitled to move against him to obtain all sorts of relief that might be possible, injunctive relief, monetary award for damages that is suffered by the owner on account of the recipient's breach. So this consequences of breach also must be very clearly uh, specified. That is what I have gathered from the important points that an NDA must contain. And the last point that I would want to emphasize again is severability. Severability is the last icon which shows that something can be severed, can be prized apart from the main body, right? The idea behind using that icon is to denote severability, which basically means that if a court of competent jurisdiction finds uh, that any portion of the non-disclosure agreement is invalid or illegal or unenforceable, the remaining provisions shall remain in full force and effect. It is a wise idea and a good idea to use such a clause so as to ensure that that the confidentiality part of the agreement survives, and the the promise on part of the recipient to keep the concerned information safe remains valid. Okay, so that is the I think that brings me to that was the last slide. I have a couple of more information, some more information that I might share in response to some of the questions that, if time permits, that I might be allowed to take. So thank you very much for this assistance on the PPT. That brings me to a close of my presentation.
Uh, Thank you, ma'am. Thank you for beautifully explaining the concept of NDA and its interrelations with patents and all other aspects. In the chat box from the students, we have received some questions, and I would like to put forward some of them, which I could note down, canceling out those which are kindly similar in nature.
Right.
Should I put it to you?
Yes. Would it be possible for me to see the questions, or it's not possible?
It would not be possible for you to see the
Okay.
questions, perhaps,
Okay.
but I have
Fine.
noted it
Fine.
down. The
Right.
first
Right.
question,
Please.
ma'am, is that what precautions should we take before entering an NDA
Hmm.
as an individual?
As an individual, if I may assume, as an individual who wants to protect the concerned IP, because this is NDA and intellectual property we are talking about, right? So the precautions are actually the 5 points that I have discussed. If you only focus on these 5 points, right, you should be in a position to protect your interests sufficiently well, right? First of all, you need to focus on what you need. What is it that you intend to protect? What information do you have that you would want to keep as confidential? Okay, and in the sense that you have no other option but to share the information with this other person, the recipient, but in order to minimize the risk, right? What exactly is it that you would want? uh, what what are the contours of the information? What is the domain of information that you would want to share with this other person, right? So first decide on that. Then always keep track. Be mindful uh, of creating that kind of a clause in your NDA. First of all, you have to sign an NDA. Only then I'm presuming that you would want to sign an NDA if you want to keep your information confidential. So decide on what is it that you want to keep confidential. Second, be mindful of creating a loophole-free clause or term in the NDA which talks about the consequences of breach. Okay, So what would happen if, yes, through this you promise to protect my information, you promise to protect, you promise not to misuse my information, you promise to do a lot many other things in relation to this information. But what if you end up breaching this promise, right? What would be the consequences? So you, both the parties, the owner of the information as well as the recipient, they have to agree on, mutually agree, of course, on what would be the consequences of breach. Okay, how much of compensation? If you want to go into the details of you want to devise a detailed sort of a clause, that also is permissible. There is no bar to it as such. So what kind of damages, liquidated damages or other damages, what kind of compensation would you want from the recipient if he breaches, right? So always be mindful of that. Also, if I may, um, so these are two of the basic things. Uh, overall overall I think one needs to have a total clarity. uh, Both the parties need to have a total clarity as to what their rights and obligations are, right? So this is what all I can perhaps give out as an answer. I hope you have I managed to answer some bit of your
Thank you,
question.
ma'am, for helpfully elaborating the situations and uh, the conclusion and the consequences which we might keep in mind while drafting an NDA, specifically the breach, consequences of breach. The next question is relating to kind of comparative analysis that can the process of sealing of a patent be compared with a non-disclosure agreement, because which I presume might be the intention of the student, that under the sealing process there is an agreement between the authority that they will protect my design or my information relating to the patent, and there's an obligation. So there's a two party, there's an obligation on another part, and under the non-disclosure agreement also there's a kind of obligation. So are these two comparable, since we are discussing in the light of IPR?
Yes, it's a good question. Yes, they are comparable. Yes, why not? In fact, uh, so the terms might not be as elaborate and might not be as you can say elaborate is the word basically. But then at the end of the day, it is incumbent on the authorities, right, to whom the patent application has been made, not to disclose it, right? So in a way, it works as a non-disclosure agreement only. Yes.
Okay, thank you, ma'am. The next question is not relating to IPR, but relating to another act, RTI. The student is asking, are RTI Act, the provisions of RTI Act and a non-disclosure agreement conflict with each other?
um, RTI and non-disclosure. I think, see, I'm not too sure about this, but then logic dictates me um, to to say as much. As I said, I'm not very sure about this because this is quite a unique question, and I haven't had the opportunity to basically think along these lines. But as I said, I think logic dictates that. Uh, uh, there could be some exceptions, right? Um, which I think we have in one of the provisions of the RTI Act, which is, I think, if I'm not too off the mark, I think it is either Section 7 or 8 of the RTI Act, which says that um, any public authority is not under an obligation uh, to to furnish uh, that information, to disclose that information, which would prejudicially affect the interests of, of certain entities. So it might be, again, I'm not too sure, it might be covered there, right? So in that sense, yes, there are certain exceptions which are there, and uh, that is all that I think I can offer, because RTI is, as I said, something that I haven't had the opportunity to at all link with non-disclosure.
Thank you, ma'am. Moving on to another, I think you perhaps find interesting that what court thinks about a non-disclosure agreement being
Mhm.
against public policy. If yes, how the test of such situation be determined? Whether there is any guideline.
Sorry, I didn't get the domain of the question. What does the court think about?
NDA being against public policy, used against public policy. I presume that might have been the intention of the question framer.
Mhm. So, see, these are the things that in such uh, situations, um, I would, like an interaction sort of a thing with the student who has put the question, because frankly speaking, what or along what lines uh, the concerned student wants me to answer is not very clear in my head, right? So, uh, what exactly is if you could throw some light on it? Yeah.
Uh, Ma'am, I think I presume it is being the student want to ask for my presumption that suppose there's a non-disclosure agreement between the government and private entity, and
Mhm.
that might be in for the purpose of protecting or kindly veiling corruption, and
Hmm.
such thing doesn't come to a public light. So such thing, if allowed by the public authority, that might lead to against public policy in general. And I presume from the language that might have been the intention. So can it be used by any authority as a tool of uh, suppressing others' voice by way of an legal instrument? It's out of the purview of IPR, perhaps uh, some
Yeah.
constitutional law aspects.
Uh, Insofar as my memory, if I may say that, goes that um, in this expression, public policy is more used in either constitutional law, domain, or in ADR also at times when we are talking of arbitration, particularly, right? When we are talking of Section 34 of the Arbitration and Conciliation Act, and there the Supreme Court mm, has uh, has sort of given uh, a certain scope to this expression, public policy. And yes, from if we take a cue from there, uh, the scope of public policy is not very narrow, it's quite wide, right? So, despite the fact that the expression used by the Supreme Court is that we are narrowly defining public policy as such, but then almost anything to everything can be brought within the fold. It all depends on court craft. Can be brought within the fold of what is against public policy, right? So yes, in that sense, if we take a cue from that, yes, NDA can be used as it seems like it why not, it can be used as means and a mechanism to suppress things. Why not? Again, I'm not sure if I've answered the question, but then
I
that is
hope
what comes to mind.
you have, ma'am. I end with the final question that after making of an NDA, is it possible to change it subsequently?
Yes, it is very much possible to change it, but then not unilaterally, never unilaterally. It has to be, any change to it has to come through mutual agreement with the other party.
So it's kind of similar to the contract
Yes,
in
yes,
which
yes, absolutely. Yeah,
a new contract takes the place of the older one.
absolutely.
Okay. Thank you, ma'am. Thank you so much. And I would like to request our Honorable Director, sir, Dr. B.A. Soti, to address the vote of thanks. Sir, am I audible to you?
You're audible. Okay, good evening, ma'am.
Good evening, sir.
Yeah, so how are you?
I'm
You
good. I'm
So
good.
it's nice. Of course, I was not there. I just entered now. I thought I could not meet you in the beginning, or I have not met you. So I thought, let me have an interaction with you. So it's nice that you came at a short notice. And when I contacted you at that point of time, you were in Dubai. So
Right.
it's nice that you landed, and then we are going to have we had this virtual uh, um, session. So it is nice. And maybe I hope sometime when this pandemic thing is over, then we can meet also, and you can come to our campus.
Absolutely,
So
sir. I would love that. And it has been my pleasure, absolutely my pleasure, to be able to interact with
so nice.
students. I think business uh, stream
चलिए बढ़िया
students are also there, right?
हाँ
Ma'am, the students consist of BALLB and BBLLB students. They are students of 8th semester. So they
Right.
have already been studying IPR under the 8th semester, and they are
Okay.
aware about constitution law and arbitration. So
Okay.
therefore, we have topic we have specified so that they could understand. Otherwise, it's a typical topic.
Right. Right. Okay.
Yes, ma'am.
That's good. Yes.
Okay, fine. Thank you, everyone. Thank you.
Thank you, sir.
Thank you, ma'am. Thank you, sir. Uh, thank you all the participants for joining. We end here this session. Thank you so much.
Thank you.